My name is Cheryl Ehrman. I'm the Dean of the Charles W. Davidson College of Engineering. Today we're finishing the Spring 2018 Silicon Valley Leaders Symposium series with a talk by Mr. John Kebeka, Director of the West Coast United States Patent and Trademark Office in Silicon Valley. Mr. Kebeka has a bachelor's degree in electrical engineering from Widener University in Pennsylvania, and he's worked at the U.S. Patent and Trademark Office, otherwise known as USPTO, for over 28 years, beginning as a patent examiner. During his career, he has served in the Office of Petitions, the Office of Patent Legal Administration, the Office of Governmental Affairs, and the Office of the Undersecretary. In 2006, Mr. Kebeka was appointed a Department of Commerce, Science, and Technology Fellow and was on special assignment to the Executive Office of the President in the United States Trade Representative's Office, where he worked on a variety of international intellectual property rights issues and played an integral role in the free trade agreement negotiations with the Republic of Korea. In 2008, he joined the Senior Executive Service, serving as a Patent Technology Center Director over semiconductor and electrical systems technologies. And then before he took his current director's role, he was a senior advisor to the Undersecretary of Commerce for Intellectual Property and director of the USPTO. As the director of the West Coast United States Patent and Trademark Office, Mr. Kebeka established and now leads the USPTO's regional office here in San Jose, which covers California, Washington, Oregon, Nevada, Arizona, Hawaii, and Alaska. Once again, please help me welcome Mr. John Kebeka, director of the Silicon Valley USPTO.
Thank you. Thank you very much. Okay, good afternoon, everyone. I think we have about an hour together, so I'm going to give you a few things. One, we'll talk a little bit about the Silicon Valley USPTO, since we're literally right around the corner, and I'd like to highlight some of the features that we have there that hopefully you'll take advantage of. I'll give you a little bit of background on intellectual property and some tips in a very short period of time, some hopefully takeaways that you'll take with you regardless of where your careers take you. And then we'll talk about some career opportunities that we have for engineers and scientists as patent examiners at the U.S. Patent and Trademark Office. So, and thank you very much for the very nice introduction. One of the things that, yes, I have a degree in electrical engineering, but you may have heard so much of my experience was in the patent legal administration or working on international legal issues, and that's because intellectual property really is a bridge between the field of law and the field of engineering, particularly when it comes to patents. So we're going to talk a little bit more about that as we go forward. But let me just go ahead and start and tell you a little bit about the U.S. Patent and Trademark Office. So the U.S. Patent and Trademark Office is led by the Undersecretary of Commerce for Intellectual Property and the Director of the U.S. Patent and Trademark Office. So it's a really long title because there's really two titles in there. One, as the Director of the USPTO, Director Andre Iancu is responsible for the day-to-day operations of our agency, where we primarily grant patents and register U.S. trademarks, and we'll talk a little bit more about the distinctions between them. And then as the Undersecretary of Commerce for Intellectual Property, the Undersecretary Iancu, serves as the principal advisor to the President of the United States and to the Secretary of Commerce on all forms of intellectual property, not just patents and trademarks, but also trade secrets, copyrights, and things like that. So, and so it's kind of interesting because the Copyright Office is actually part of the Library of Congress, which is in the legislative branch, but for the executive branch, the head of the USPTO is the lead on IP policy matters, as well as the enforcement of those rights domestically and abroad. So the Silicon Valley USPTO, we opened 2.5 years ago. We're actually in City Hall. We think we're the only federal agency that's in a City Hall campus. So how many of you have walked down 4th Street alongside City Hall? So, all right, cool, very cool. So what we tried to do was build in this educational component throughout our space. So even as you're walking down the street, you may see the big glass panels there. There's a little bit that you'll learn about intellectual property and as it relates to each of the 7 states in the region that the West Coast Regional Office covers that you heard earlier. So, and I'll talk a little bit more about that in a moment. But first, just to highlight, we're open every day from 9 to 5. We have walk-in facilities, and we have search systems that are the same search systems our patent examiners use every day to mine through millions and millions of documents to see if someone's invention has been earlier disclosed or published or patented, for that matter. So we have a public search facility. We do training workshops, and I'll talk a little bit more about those. And then we also have a variety of different things, interview rooms, hearing rooms, and other meeting spaces I'll talk about. But first, just to highlight, we have about 80 patent examiners. The agency overall has 8,500 patent examiners. All of them, most of them are engineers. All of them are engineers or scientists with at least engineering math. And they work, about 6,000 of them work from their homes most of the time. And the rest either work here in the Silicon Valley office or at a headquarters or in one of the other 4 regional offices. So in addition to Silicon Valley, we have one in Denver, Dallas, and Detroit. So, and these are the 4 different regions, and the Silicon Valley office I mentioned has been open 2.5 years. The first regional office ever for the USPTO opened in July of 2012, so it's almost 6 years old. Prior to that, in our 229-year history as a patent office, we've never had regional offices, so this has been a really big deal for the agency, and it's just been a pleasure to kind of be here since the beginning to help start up the office here. So here's San Jose City Hall. This is the wing, and then there's the rotunda and the tower, which are over here. So we take up pretty much the 3 stories of the wing, and you might see I photobombed my employee that was taking the picture. Anyway, so so each of the floors serve a different purpose. The first floor really serves as a hub of outreach and education for the community. We do a lot of programs, and we also host a lot of programs. We also, oftentimes will work with other organizations or even elected officials to host their programs in our space as well. The second floor is pretty much all patent examination, and the third floor is myself and the Patent Trial and Appeal Board judges that basically the judges primarily are responsible for if the examiner thinks it should be rejected and the inventor thinks it should be patented, a panel of 3 judges adjudicates whether or not the examiner's position is correct and should be affirmed or whether it should be reversed. And then we also have some other proceedings that we do there as well. So I talked about the educational component. So as you walk down 4th Street, when you go to the entrance of our building, this is what you'll see, almost actual size actually when we look at this, which basically highlights that California has long been really truly the epicenter of innovation for innovation coming out of the United States. We get about 600,000 patents a year, actually over 600,000 patents a year, utility patents, which we'll talk more about. And of those, about half are filed from other parts of the world and half are filed here within the US. And of the US filings, about 1/3 are being filed, just under 1/3 are being filed from California alone, and just over 1/3 if you take the whole 7-state region. So it really is the most innovative region in the country. Okay, we had 3 primary goals. I'm going to talk about some of the services and talk about some of our outreach, but really we wanted to be able to tap in to new talent. So we hire our examiners in the regional offices. We also hire some out of headquarters. And then we train them, and then ultimately they either decide to stay as examiners in the regional office or they work at home and they decide to work somewhere else around the country. So I've been really pleased with the caliber of folks that we've got here. We have a class that's just finishing. We hired them in January, and they have 4 months of training. And so they graduate up to the 2nd floor to their offices next week. And I think there's about 20 of them, and about 20% are from San Jose State. Okay, outreach services, I'm just going to skip this in the interest of time because I have other slides to talk about it. Regional focus for workshops. We really like to say that our mission is quite broad. Our goal and our mission is to engage with the innovative and intellectual property community across the innovation ecosystem at all levels, from K through 12 to advanced international IP policy programs and everything in between throughout our entire region. So that gives us a pretty big mission. So really, as long as we can connect it to our mission, we want to do it. We're really bad about saying no as well. But one of the things, we do tech-specific partnership meetings. We have a lot of lunch and learn programs. I'm going to give you a very abbreviated types of IP in a moment, but we offer monthly programs, which is a deeper dive on patents, and Trademark Tuesday, second Tuesday of the month, gives you a deeper dive on trademarks. And then we also have periodic, more in-depth IP programs on law and procedure. Okay, so some of our services, this is, I think, one of the best things that we offer because it's very personalized. As I mentioned, we're open from 9 to 5. You can come in and ask some questions, and we'll see if somebody's available, but you can also go to our website and sign up for a slot with an expert in a particular field. So whether it's, patents expert, or if we happen to have a trademark expert on hand, or one of our other colleagues from across the agency. And you can sign up and then come and meet with us for about 30 minutes or so and talk about your invention. We can't give you advice, but the nice thing about talking to someone from the U.S. Patent and Trademark Office, as an employee of the USPTO, we waive our rights to get our own patents while we are employees of the USPTO. So we are considered pre-disclosure. You can tell us your invention, and we can help you and help craft a search for you, and you don't have to worry that that's public disclosure. And we're going to talk more about what that means in a moment. Interview rooms, these are actually really cool. I was just meeting, I came directly from the new Samsung facility down on First Street, and was meeting with a bunch of patent examiners that convened there, as well as a bunch of intellectual property attorneys that all have work at Samsung. And we were talking about finding ways to bring services to the community, and these interview rooms really help to do that, especially since our employees, so many of them, are working elsewhere around the country. You can really take advantage of some high-tech equipment within these rooms to really replicate an in-person experience. So it's kind of cool, and the examiners like it too. This is the public search room. So we have 6 terminals here. We also do workshops to talk about how to search for patents. And then, so we do training, and then we go to the terminals themselves and do some live exercises. These have actually been really well received. We have 6 terminals. Headquarters has about 150 terminals. And a lot of times, there are these search firms that their primary job is to search for prior art, search for technology before an applicant files their invention to see if it had been patented earlier. And there are firms that basically camp out in our public search room in Alexandria, and that's their office. And so I'm surprised no one's camped out in sunny California yet. But we do, these terminals are free for use, and they're limited to access just to our systems. But at the same time, it's the only way to really get access to these systems. I'll talk about another way in a little moment. And then we have these hearing rooms. I mentioned the Patent Trial and Appeal Board, so we do these proceedings. If this is something you're interested in, we also have on our website when you can attend these hearings and actually view the proceedings that take place in our hearing rooms. Okay, so I had to do that really quickly because I know we're, so I got 45 minutes to talk about all the different types of intellectual property. Okay, so I've been known to spend an hour on just this one slide, but I'm going to try not to do that. So these are the different types of IP. We have utility patents, design patents, copyrights, trade secrets, and trademarks. And one of the interesting things about these, and why I like to talk about them all together, is as an innovator, as a creator, when you're creating and innovating and inventing, intellectual property is specifically designed not to be a one-size-fits-all system. And that's why there are all these different types that give you different kinds of protection. And sometimes you might need more than one form of intellectual property to protect what it is you want to protect to secure your business assets or your business strategy. And other times you may decide that, yeah, I could get a patent on that, but it might not bring But it might not be strategically valuable for me to do that. And those are decisions that you can make once you understand the need and the benefits of having all of these different types of IP. So I think I'll start at the bottom and I'll work my way up to the top. So we'll start with trademarks. And trademarks are really interesting because it's really anything that you create that is a distinguishing feature to a product or service that you have in the marketplace. So the definition's words, symbols, logos, designs, or slogans that identify and distinguish products or services from other products or services in the marketplace. And trademarks can really be a variety of different things. So you see Coca-Cola is pictured here, so I'll use that as my example. But Coca-Cola has the words in script, right? So that's and then there's this little fancy white swoosh that runs under it. So if the words were different, but the swoosh and the color and the script were there, you might think that is Coca-Cola, so that may be confusing to a consumer. Trademarks prevent that from happening. But you can get a trademark for a variety of different things. It can be words like Coca-Cola. It can be words and an image, like the words Coca-Cola with the swoosh. It can be just the image itself. It can be a texture. There's a winery up in Napa that their wine bottle has a leather texture to it, and that's their distinguishing feature from other wineries in the marketplace. It can be a color. Does anyone know the slogan, "What does brown do for you"? UPS, right. So UPS embraced the color brown in its delivery services and now have been able to trademark the color brown to distinguish its delivery service trucks from other delivery trucks on the marketplace. So you can't just decide, oh, I'm going to look like UPS and paint my truck brown, and you would be infringing on their trademark. There's a lot of different color examples. It can be a sound, and I have a really bad voice, but if I went bum, 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 does anyone know what that is? NBC, yes, that's right. I know. I know, it's a little different now. But yeah, you can use a sound because NBC uses that chime to distinguish its channel, TV channel, from other TV channels in the marketplace. So if you think about it, there's really, there's actually there's an insulation, like for your attic, that has some strawberry smell. So it can be a smell. And so there are all these different ways where you can distinguish your product from other products in the marketplace, and trademarks gives you the flexibility to do that. The nice thing about trademarks is they last for as long as you're using the mark in commerce. There are these renewal fees that you have to show that you're still using, and you have to certify that you're still using the mark in commerce over time. But ultimately, as long as you're using the mark in commerce, it can last forever. Okay, questions on trademarks? No? Okay, good. All right, so let's go to trade secrets. So trade secrets are really interesting because they can be also a variety of different things. So it says formulas, methods, devices, or compilations of information which are confidential and gives a business an advantage, right, a strategic advantage. So very popular, probably one of the most infamous trade secrets is the formula for Coca-Cola. And Coca-Cola goes through great lengths to protect that from that recipe for the formula for Coca-Cola from entering the marketplace, for it being known exactly what the formula is. So trade secrets, it may also be a curing time for a compound, or it might be an algorithm within a computer software code or module. So the difference with trade secrets is there's no trade secret attorney, there's no trade secret office per se. Trade secret is kind of a state of intellectual property. It's only provides you value as long as you can keep it secret. So if it can be reverse engineered, or if it can be separately discoverable, or if it's disclosed even inadvertently by the trade secret holder and put out into the public, there's really not much you can do. So if Pepsi, I'll say for example, was able to recreate the formula for Coca-Cola and market it, there would be nothing Coca-Cola could do about it. And there's actually a story from just a couple years ago where apparently an employee from Coca-Cola went to Pepsi and tried to sell the formula for Coca-Cola. And Pepsi immediately contacted Coca-Cola's legal team and said, hey, someone's trying to sell your formula, because they don't want to acquire it through illegal means. If you steal someone's trademark, now you're subject to criminal laws. And we recently updated our trade secret. In 2016, we updated the trade secret protections in the US through the Trade Secrets, the TSPA, the Trade Secret Protection Act. And so, but still, you know, if it's separately discoverable or reverse engineered or inadvertently disclosed, there's nothing you can do about it. You may all be familiar with Mrs. Field's cookies. That cookie recipe is available on the internet because it got disclosed. And there's nothing you can do to pull that back once it's in the public domain. Very little you can do. Okay, moving on to copyrights. So copyrights are really anything that you create that you can embody into a medium. So let's say, for example, books, right? So I author a book, it gets published, so the words of my book get printed on paper, so paper would be your medium. Same thing with photos and being printed, you know, either available on a computer screen or available, you know, as a printed image. Music as well. Fine art, if I sculpt, you know, make a sculpture out of clay, clay is the medium, and the sculpture is my now copyrighted work. So it works for graphic images, videos, films. It also works for computer programs, which is kind of interesting. And it works for computer programs because the computer program is stored in memory, which is computer readable medium, right? So it's another form of medium. So as soon as it's embodied into the medium, you have some common law rights. We do have a copyright office, as I mentioned before, is in the Library of Congress, and there are copyright examiners. And getting a federally registered copyright gives you some other advantages that you may want to take advantage of. But just creating the work and embodying it into the medium gives you some common law rights with respect to protecting that work from being copied. So going back to computer programs, if someone copies my computer program or pirates my computer program and then starts selling it, you know, I have some rights to go after them copying the program. What the copyright would not cover, though, is what the program was doing, the functions that that program enabled. So if you were able to take a computer program that performed a certain function and able to program it in a different way, but still achieve the same result, you would no longer be subject to copyright restrictions in many instances. So if you want to protect the function and actually what the program can do when it's operating on a computer, well then we're going to be talking about inventions. And that's really where that would, that type of protection would fall into play. So you might even, so if we are talking computer programs for the moment, you could get copyright protection for it as well as patent protection. And you may even be able to get some design patent protection as well. So let's talk a minute about that. So design patents are really they're patents that protect just the ornamental feature, not what it's doing, but really what it looks like. So I jumped ahead because I've been trying to use this Coca-Cola analogy. So I'll take a quick step back and say for copyrights, who can give me an example of what a Coca-Cola copyright would be? Yeah, exactly. The jingles, the commercials, things like that. They're, even if you took the label, even though the label has a trademark on it, but it has other information as well, and you copied the label, you would be violating not only trademark, but also the copyright laws. So, all right, going back to design patents, so ornamental, non-functional designs. Again, Coca-Cola, it's the shape of the bottle. If I had taken the red label off of the bottle, you would still know it was Coca-Cola because you recognize the bottle, right? And Coca-Cola does get design patent protection for its bottles, but it's kind of interesting. You might notice design patents only last 15 years from the date that the patent is granted. And so over time, you'll see the bottle kind of evolves somewhat. Different types of grips, different types of features on that hourglass shape that we recognize. But so we're talking about the shape and recognizing the shape. So hey, doesn't that sound like a trademark, right? So because the shape of the bottle is actually a distinguishing feature of that product in the marketplace from other carbonated beverages. So yes, so Coca-Cola also protects the shape of the bottle as a trademark, in addition to protecting aspects of the bottle as a design patent. So hopefully that makes sense. So moving on, in the interest of time. So let's talk about a different type of bottle, Clorox bleach, right? So everyone can visualize this kind of white bottle with this handle. And the handle is actually formed in a very specific way. So, so yeah, you could get a design patent for the bottle. But the way that handle is shaped is the handle actually goes all the way up to the very top of the spout, and it's hollow and goes down to about midway of the bottle. And so when you pour the bleach into your laundry machine, the air travels through the handle and it doesn't go glug, glug, glug and splash bleach everywhere, right? So, hey, well, that sounds like that's no longer just ornamental, non-functional. It actually overcame a problem of bleach splashing in your, on your clothes while you're trying to do laundry. So now we're talking about inventions. And that's where inventions come in, is they're functional, and they can be really anything. The inventions relate to products, methods of manufacturing the product, compositions of matter, as well as any improvement of those things. So you can get improvements, follow-on improvements on your inventions. And so we get, like I said, about 600,000, over 600,000 utility patents every year. And we get about 40,000 design patents, just to put it in perspective. Utility patents last 20 years from the date of filing, whereas design patents are 15 years from the date it's actually granted. So there's a distinction there as well. And I'm going to talk more about utility patents, but I first want to stress why intellectual property is important. And so we do a much longer program where we talk about intellectual property. And intellectual property strategy is an integral part of every business strategy. And there's a lot of reasons why a company may wish to pursue their intellectual property. And whether it's to get some investment and funding, also to deter others from entering a marketplace, for example, and also deterring someone from suing you for maybe infringing their patent. And we'll talk about the extent to which the exclusive rights of patents would apply here. But it also increases your leveraging power, when you're trying to be acquired or merge with another company. And it is a property right. So the Supreme Court just confirmed that last week. We were very happy. But it is a property right and adds value to a company's assets. But I think more importantly is it's global. And the one thing that's interesting about our patent and trademark systems is you have to get the protection in any country where you want to secure and enforce those rights. So if you get a patent or a trademark in the United States, then you can enforce and prevent someone from using your trademark, and you can exclude them from making, using, selling, or offering for sale your patented invention, if you have a patent in the US. But it will not give you the ability to stop an infringer from copying your invention in another country unless you have already sought patent or trademark protection in the respective other countries. And so we have mechanisms to help stakeholders and inventors do that. So you can file in multiple countries, or at least stake your claim that you will file in multiple countries through a more streamlined process, but it does get complicated. All right, so I alluded to this already, the exclusive right of a patent. So patents give the right to exclude others from making, using, selling, offering for sale, or importing their claimed invention. So trademarks, if you remember earlier, you had to certify that you were using the mark in commerce. So trademarks actually give you the right to use that mark in commerce, right? Patents is kind of a little bit of the opposite. It gives you the right to exclude others from making, using, selling, offering for sale, or importing the invention. And that's a really interesting distinction. But let's say, for example, and I usually have a coffee cup at this time of day with a nice cardboard sleeve to prevent my hand from burning in the coffee. So let's say that was my invention, right? So I invent a corrugated cardboard sleeve to thermally insulate a user's hand from a hot beverage, right? And so that might be my invention, right? So I can exclude anyone from making, using, selling that invention, right? But let's say someone sees that and says, oh, well, that's great, but if I add a handle to that invention, wouldn't that be cool, right? So they may be able to get a patent on the same sleeve, but with a handle, if the examiner says that wouldn't be obvious, which of course we all think it would be, so if someone has a patent for the sleeve with the handle, and I have a patent for just the sleeve, right, I can exclude them from making their sleeve with the handle because their patent reads on my patent, right? So their patent's narrower, corrugated sleeve with a handle, mine's just a corrugated sleeve. So because my patent is broader, if they were to make and use their invention, they would need to seek licensing to be able to use my part of the invention. So just because you have a patent on it, it doesn't give you the right to make and use it. You would need to make sure that you have freedom to operate, that your patent isn't infringing any other patents that are currently active in the marketplace, or active and paid up in force at the USPTO. Does that make sense? Okay, good. All right, I mentioned the limited term. I mentioned it's no worldwide patent. So a really interesting thing about patents is we give you this kind of limited monopoly for up to 20 years from the date you file. And there's a way to extend that a year, and we'll talk about that in a moment. But in return, you have to tell us how to make and use your invention. We need to know precisely how to make and use the invention. And we also need to know precisely what is the scope of the protection you're seeking. So I may have, and so through that, you have to do the patent disclosure. And the patent disclosure requires that you explain your invention in such clear and concise terms to enable someone of ordinary skill in that technology to be able to read the disclosure and make and use the invention, right? So let's say my disclosure said I invented a corrugated cardboard sleeve, and then I also envision where I might be able to take that sleeve and add a handle to it. But if my claims just talked about the corrugated cardboard sleeve, and didn't have any reference to affixing a handle or manufacturing it with a handle, I don't have protection for the handle. I've disclosed it in my patent application, but if I haven't claimed it, I can't go after somebody for making something I haven't claimed and received patent protection for. And then the reason we do this is not only to bring certainty to the system, but also to encourage others from finding new ways and spurring technological advancement. So through the patent disclosures, someone might read my disclosure and be like, corrugated cardboard, I'll make it in neoprene. Or I'll find some other foam type material that's cheaper to manufacture and has better insulating properties, right? And they may get a patent for that, right? So they're improving it. And then someone else might come along and think of a new way to do it where it's reusable or something along those lines. So, so there's a lot of, so that's just one simple example. But if you think of, one example I really like is the inkjet printer head for inkjet printers, right? So that amazing technology, I think there was, they were inducted into the Hall of Fame for inventing it. But that technology has spurred so many other industries, not just for in inkjet printers, but also in depositing organic LEDs onto platens of glass for our LED TVs, right? Or depositing samples in biotechnology and genetic sequencing to do millions of samples. The same kind of printer head technology has been used. Even in 3D printers, it's evolved and created like 3 very distinct industries outside of printers. And it's all because of this incentive to invent and the incentive to improve upon what's been invented. Okay, how am I on time? Good, okay. So let's take a moment and talk about a couple things. So the United States, we transitioned in 2013 to a first inventor to file system. Prior to that, we would go through great lengths to figure out who the first inventor is. And it wasn't a really equitable process in many ways. So we adopted the standard the rest of the world had and had been encouraging us for decades to adopt, where now it's really who the first inventor is who the first to file is considered the inventor. And you know, there are some exceptions, but that's primarily the rule, and everything else is going to be very complicated if that's not the case. So file first, file fast, that's kind of the overarching message, and we do have some mechanisms to give you patent pending status for very little, much less effort than a traditional patent application, and I'll talk about that in a minute as well. If you disclose your invention before you file, you put yourself at a lot of risk, especially in a first-to-file system, because someone may hear your disclosure and they may file their own application. And if you haven't already received patent pending status before making that disclosure, then you put yourself at risk. If you disclose before you file, I think the next slide's probably, let me go one more. Okay, so let's say here I disclose and I have not yet filed a patent application. There's two types, I'll get to them in a minute. In the US, you have a year from your disclosure in the US till when you can file and still be able to get patent protection. Past a year, we will use your disclosure against you and basically say, well, whatever you disclosed prior to filing, since it was over a year ago, we now have to use that in showing that that subject matter was known in the field and could be used and prevent you from getting patents. Now, in all of Europe and in Japan, you disclose before filing, that disclosure is used against you. They have no grace period. Some countries have 9 months, some have 6 months, some have 12 months like us. So the safest thing to do, especially if you're thinking about international filing, is file first before you disclose. And what you disclose is a big deal. So let's say my invention is I've invented a 3D printer on 3D printers. And let's say I tell you I invented my 3D printer and it's 50% faster than its preceding model, right? I haven't told you how to make and use the invention, right? Remember the disclosure was, you know, it has to, you know, someone of ordinary skill in that field has to be able to, you know, read, hear, see my disclosure and be able to make and use the invention. If I say I made a 3D printer 50% faster, I haven't told you how I did it. But then if I start, you know, and all the engineers will laugh at me because this doesn't make any sense. But if I say that the 3D printer, you know, I boosted the feed speed and, you know, ran servos in parallel and, you know, amped the power supply, you know, then I may be telling you a little too much that has started that, okay, well, I'm disclosing too many details of my invention. Someone skilled in that technology may be able to make and use my invention from what I have disclosed. So if I didn't already have patent protection, then that 1 year clock starts in the US, and I've kind of implicated myself internationally if that was something I was hoping to do. So it is really important to understand what you can say before you file, and then you know, when you have said too much is when you've really kind of triggered that enabling disclosure. One thing I really want to highlight is I can disclose my invention to you. If I said I have a 3D printer that's 50% faster, that's fine. You know, I haven't triggered the disclosure clock. But if I offer to sell you my 3D printer that is 50% faster, that does. And the reason for that is because I'm basically saying I've reduced my invention to practice, and I'm offering it for sale. And where that gets really tricky is in crowdfunding campaigns, because number one, there's been no case law on them because they're all new. But if I put up on a crowdfunding campaign, you know, give me $500 today, and in 6 months I'll give you my 3D printer that's 50% faster, I have started a disclosure clock. At least most of us think so. There's an argument to say that it's not an offer for sale, but most people agree that it is. And the bigger issue is, if you just file your application before you join a crowdfunding campaign, you kind of eliminate trying to figure that out, right? And it can get, I have a feeling that, that this will be a test case one day, and it will go into the courts and it'll be very expensive. And if you just filed your application before you joined the campaign, you would have eliminated that kind of challenge. And so that's a good opportunity for me to talk about the provisional application. So the provisional applications are a way to get a patent pending status and a filing date without all of the complicated requirements that actually go into the utility patent application. What all we require in a provisional application is one of four things. Yep, okay, good. And so we need that disclosure that enables someone of ordinary skill in the art to make and use the invention, and any drawings that make sense to go along with that disclosure. And then it's the filing fee and a cover sheet. And that's it, and you get patent pending status. And the other nice thing about this is it's pretty cheap. So the fee is, I'm going to do my math. So for micro entities, which are for very small inventors that have not yet filed more than 5 applications, and there's a income limitation. You can't make more than 3 times the national average salary. So right now, that 3 times number is just a little over $150,000 a year. So if you make less than that, and you haven't given the rights to an entity that makes more than that, you can get 75% off of almost all of our fees. So the provisional application filing fee would be $70. If you don't qualify for that, it would be twice that, so it would be $140. And then large companies pay twice that, so $280. But so it's great, $70, you can get a patent pending status. It gives you the ability to maybe feel a little more comfortable when you're pitching an idea, or even in some cases, I know that many that have worked on senior projects, that may have patentable features in them, may have filed a provisional application before disclosing. Others, again, it's a decision you have to make: is there strategic value in seeking patent protection for this? Because this application only lasts a year. The $70 provisional application lasts 1 year. By the end of that year, you have to do one of 2 things. One of them being nothing, and if you do nothing, we will treat it as if this application has never been filed. It won't go in the public domain, and it just basically goes abandoned. The other thing is, before the end of that 1 year, you file the utility patent application, and then you claim priority to what you've disclosed the year earlier. And so it's a good way, and it also this year gives you the opportunity to maybe fine-tune your invention a little bit, as well as to perfect the filing of your non-provisional application, which has more complicated legal parts to it. I mentioned before, your claim for your invention has to be clear, and you have to spend some time crafting what your claim strategy is going to be. So I'm sure I don't have time to talk about claims, but the only thing I'll say about patent claims is it's very similar to a claim for personal property. If you have your home, and your home sits on half an acre, and then your neighbor all of a sudden one day it says, oh, well actually I'm going to build a fence 10 feet inside what you think is your property line because I think it's my property line. And so now you have these overlapping claims for personal property, and patent claims are very much the same way, but instead of using physical boundaries for like personal property where you have telephone poles and stop signs and fire hydrants, you actually have to use words to define the metes and bounds of that claim for patent protection. So that takes some time. And then this application, our fees are also relatively low. It's about, I want to say, $370 for a microentity to file the non-provisional application. But we also recommend that in order to make this filing, that you seek the counsel of a registered patent practitioner who can help you with crafting your claim strategy, crafting your application, and many times applicants will use a registered patent attorney or patent agent even in the drafting of a provisional application. So all I'll say is our fees are low. I won't say anything more about that. Okay, let me see, was there anything else? This is kind of like the, can't I just keep it secret? So here, we talked about trade secrets, so we already know everything we need to know about that. But let's say the opposite. What if I just put it in the public domain? So rather than seek patent protection, I'll just publish it, right? Or I'll put it up on a website, or there's a lot of different ways to get that information out into the public domain. And so now that it's in the public domain, no one else can get a patent on that, right? And to some extent that's true. Like an examiner can use that disclosure to prevent a similar application from being patented. But also, kind of going back to the earlier slide, is those disclosures spur innovation. And they create follow-on innovations that are likely to, that may have been protected if you had sought patent protection, much like my sleeve example. You may have been able to get broad patent protection, that any follow-on innovation would still read on your claims, that you would still need to, they would still need to seek licensing, and you could be subject to some revenue for your invention in that regard. So it really just protects very narrowly what you've disclosed, whereas patents give you some breadth and some wiggle room and some ability to get patent protection, to enforce those rights down the line if you choose to do so. Okay. Any questions on patents? Yes.
I actually have a question. Recently in March, I heard that there's news that Oracle won against Google, suing them for using Java in their Android application. And I know that I'm a CS student, a computer science student here in the university, and most of the projects that I do use software that other people have made. So should I be worried if I make a project and I might be sued for using someone else's platform that they've made public?
So it's a good question because it does overlap, and many high-tech companies will do a combination of like open source, which is a different thing, right? Open source, you're agreeing to the terms of that license, right? So you have to agree to whatever terms that respective open source entity has. Similarly, with patents, yes, you can get patents on, and we didn't really talk too much about it in detail because it's one of the more challenging areas of the law, but you can get patents on software-enabled inventions, but you have to show how the software makes a computer or whatever is run, the microprocessor or the device that's running the software, do something significantly more than it could do prior to that software being loaded. So there's like a legal standard in there as well. And a lot of the battles that you're seeing now are a result of that legal standard. And that came out from the Supreme Court in 2014. And we've been getting more and more guidance since then. But at the same time, we're trying to bring as much clarity to the system as we can. And anytime there's an adjustment to our law, we usually have to rely on the court systems to figure out like where the bright line is before you can move forward. But one of the things that a lot of companies do is something called freedom to operate, where they'll do a search to see if what they want to do is covered by any patents. And there's companies out there that do those types of searches. But you can also do searches as well on your own to get a general sense of what's out there that relates to what you're trying to do. Other questions? Yes?
In the past, I know that there's been some aggressive patenting by large companies in order to kind of hamper smaller competitors, particularly in biosciences where people have patented like particular gene sequences and things like that are kind of ubiquitous and that really make it hard for, it's like deliberately using a patent as a weapon to disable potential competition. This has also happened in terms of alternative fuels, where large companies like Exxon and stuff, who are now happily advertising how great they are for developing green energy from algae, actually bought up key patents in that area from smaller developers in order to prevent people from progressing on that over the past 20 years. You know, and now they're trying to pretend like there are all these great inventions about it. Do you find that that is still going on? Does the patent office have anything to do with trying to stop that kind of practice?
So with respect to kind of the innovative side of that, you know, there's not much we do as an agency. So another example I hear all the time is like the car tire industry. You know, and I have no idea if this is true, but I've heard that some of the car tire manufacturers have really advanced car tires that would last like hundreds of thousands of miles that they don't put on the market, and at the same time because they're still generating revenue from their other patents, right? And they invested significant amount of research and development into getting to where they are today, even though they may have. And again, I don't know if it's true, but I think the analogy applies. They may have more advanced protection in their patents that is not yet on the market, but it could be because they're still generating revenue from what they already have that's covered under patent protection, and they won't need to maximize their return of investment. Especially in the biotech area, they're spending tens and sometimes hundreds of millions of dollars doing research to get certain biotechnology innovations out into the public domain, but even the patent protection, it's all a timing issue as well. And that's one area that's also very challenging. Like biotech and software are two challenging areas. So our job is to look at the invention and look at the field of prior art and see, is it new, is it novel, is it clearly described, and is it is it eligible for utility patent? Those are our four criteria. And we don't get into the regulatory regime or get into any sort of compulsory licenses, which is a compulsory license is when a country takes a party's patent for their own use. And we don't do that. Yes?
Is there any way to do search through the database outside of your office over there? Can you do it from home?
Yeah, so we have one at uspto.gov, which is very antiquated. I think I was training on it. I was delivering training on it over 15 years ago or something like that. And if you know how to use it, it's somewhat helpful, but it's not the best tool. There are free and public patent search engines out there as well that use more of like a weighted search. The examiner's search system is much more structured. So it takes a while to, it's basically was designed for examiners by examiners, and it's a way to really focus in and find that needle in a haystack in a much more discrete way than trying to mine through, which is oftentimes an unfiltered search on the public website. So as far as how to access our current system, which is only available in our public search room, it's also available in patent and trademark resource centers around the country, one of which is San Jose State Public Library. So they have up in their San Jose Public Library Works section, I think it's up on the second or third floor, they have a couple terminals there as well. And they've also come to attend some of our workshops on how to search and how to help members of the public and guide members of the public that come in to them to help search as well. So that's another opportunity. The nice thing with them is they're open later as well. We close at 5. So you actually gave me a really good opportunity to segue onto a couple of things, and I think I have 5 minutes. Is that right? Okay. So I'm just going to go through this really quickly, and I have a slide at the end which has a link to all of the things that I'm about to show you very quickly. But also in the back room, I have this document, which on the back has all of the links as well. And this is just these 4 publications, our basic guide to filing a provisional application, what's a non-provisional application, general information on patents, and general information on trademarks. But in addition, it has all these other resources. And so I know I went through this really quickly, so if you still have questions about what type of IP might best suit you for your particular need. You can take the IP awareness assessment tool. It's about 35 minutes or so, and at the end it will say, oh, based on your responses, it looks like you may want to protect as a copyright or a trademark, and it'll give you additional links and resources to help you. So that's one way you can go about it. I just mentioned the Patent and Trademark Resource Center. So again, the closest one to us, we have one in Sunnyvale. There's one here in the public library on 4th and San Fernando, and there's also one in San Francisco. We have, the Patent Pro Bono program. So we have the California Lawyers for the Arts. And for financially under-resourced inventors, you can actually get free assistance with drafting your patent application, filing your application, and even responding to office actions from the USPTO, all free of charge if you qualify for the program. So that's a great program as well. And similarly, let's see, close. So you have to, I thought there was a slide on here, there's not. So it's the California Lawyers for the Arts, and if you just go to uspto.gov and type in Pro Bono program, it'll tell you more about it. We also have law school clinic certification programs. So down the street, Lincoln Law School is actually our closest partner, and this is where law school students that are wanting to become patent attorneys get experience by helping under-resourced applicants prosecute their application and create their applications, all free of charge as well. And there's some requirements on here as well, because for under-resourced innovators. All right, there's the links, so I'll leave that up for a moment. But can I say two things real quickly? Sorry, because I forgot to have all these slides at the end to talk about the careers at the USPTO.
Jobs.
So I apologize for that. The Patent Examiner Experience Extern Program, we just, timing-wise, at the end of the semester, we've just closed out our selections for this summer, but we also offer this throughout the year as well. So if there is an opportunity, really anytime throughout the year or next summer, to participate as an extern, you work side by side with patent examiners, and it's a really great experience. So we've been really fortunate with a great group even here since the office has been open, and a couple of them have actually become patent examiners after they've graduated. So it's uspto.gov/jobs, student programs, or you can just type externs in the search box. Patent examiner positions, as I mentioned before, all of our examiners are an engineer or scientist. We have a lot of great benefits. We offer full tuition reimbursement for law school as well. So because the job is really 50% applying what you've learned in engineering school and then 50% applying what we've taught you about patent law, we do offer the reimbursement for law school. So that's another great reason, and I've already kind of alluded to our work at home programs, which will add another nice layer of work-life balance and flexibility. So our jobs, are really to determine whether or not the patent's granted, and I won't go through all of the different details, but we basically figure out what the invention is, search for, see if anything's been existing previously, and then articulate our findings back to the applicant to ultimately determine whether or not the application is going to be patented or abandoned. It's a federal agency, so U.S. citizenship's required, and I already touched on the eligibility requirements of engineering degree or science degree, typically with at least engineering math is the basic requirement. And I'll leave this here. So basically, you double your salary in 4 years. But okay, and I'll leave this up if you're interested in learning more from our job site. We have one current vacancy announcement that's open now that closes on June 5th, but it is for Alexandria headquarters. It's not for the Silicon Valley. So, okay, I know I ran through a whole bunch of stuff. Hope that was helpful. I'll be around afterwards if you have some questions. Thank you all very much.
All right, let's thank the speaker again.